Welcome to today's Legal Insight. We're analyzing an important case under the Consumer Protection Act, 1986, Bhupesh, Khurana and others versus Vishwa Buddha Parishad and others, 2001. This case highlights the importance of consumer rights in the education sector. First, let's identify the issue. The key question was whether Vishwa Buddha Parishad, which operated an educational institution, misrepresented its courses and affiliations. The institution claimed that its medical courses were recognized by the Medical Council of India, MCI, and promised students a valid degree upon completion. However, the students later discovered that these claims were false, leading to financial and career losses. The issue was whether the misleading claims and failure to provide the promised education constituted unfair trade practices and deficiency in service under the Consumer Protection Act, 1986. The institution's misrepresentation caused significant financial and professional harm to the students, leading them to question their legal rights. The case also examined whether students paying for their education could be recognized as consumers, entitled to protection under consumer law. The Consumer Protection Act, 1986, was designed to safeguard consumer rights against unfair trade practices and deficiencies in service. Under this law, any organization or individual providing goods or services for consideration is accountable for the quality and legitimacy of what they offer. If an institution advertises false claims, misleads students, or fails to deliver promised facilities, it can be held liable for deficiency in service and unfair trade practices. This legal provision ensures transparency and accountability in the education sector. Applying the rule to our case, Bhupesh, Khurana and several other students enrolled in the medical course offered by Vishwa Buddha Parishad. They paid substantial fees under the belief that the course was accredited and would enable them to pursue a medical career. However, they later learned that the Medical Council of India had not recognized the institution or its courses. This revelation meant that their degrees would be invalid, jeopardizing their professional future. The students argued that they had been deceived by false advertisements and misrepresentation. The court had to determine whether the institution's actions violated the Consumer Protection Act and if students were entitled to compensation for their financial loss and emotional distress. Finally, let's look at the conclusion. The Supreme Court ruled in favor of the students, holding that Vishwa Buddha Parishad engaged in unfair trade practices and deficiency in service. The court reaffirmed that students paying for education qualify as consumers under the Act, making them eligible for protection against fraudulent claims. This judgment emphasized that educational institutions must be truthful in their advertisements and cannot make misleading claims to attract students. Any failure to deliver what was promised in the prospectus or promotional materials could result in legal action. As a result, the court ordered the institution to compensate the affected students for their financial losses and the distress caused by the false claims. This case set an essential precedent in consumer law, reinforcing that educational institutions are accountable for their commitments. In summary, Bhupesh, Khurana and others versus Vishwa Buddha Parishad and others, 2001, reinforced the rights of students as consumers under the Consumer Protection Act. It served as a landmark case in ensuring transparency and integrity in the education sector. Thank you for watching.